In 1968, the Nelson family hired Elmer Gertz, a prominent Chicago attorney, to bring a civil suit against a Chicago police officer. Previously, the officer had been criminally prosecuted for killing their son. During the course of litigation, Gertz was featured in a magazine called American Opinion. Gertz had little to do with the police officer's criminal prosecution, but the article accused him of masterminding the whole thing. The magazine claimed it was all a frame-up as part of a vast conspiracy to discredit law enforcement. Many of these statements were blatantly false, and the magazine's managing editor published the material without attempting to verify its truth. Gertz sued the magazine for defamation in federal district court, claiming damage to his reputation as both an attorney and a citizen. After a jury awarded Gertz $50,000 in damages, the publisher filed a motion for judgment notwithstanding the verdict. The court granted the motion, applying the standard articulated in New York Times v. Sullivan. That case held that a public official must prove that a falsehood was published with actual malice. Finding that Gertz couldn't meet that standard, the district court issued a judgment in favor of the publisher. On appeal, the Seventh Circuit affirmed, and the United States Supreme Court granted cert. The issue before the Supreme Court was whether a publisher of defamatory material can claim constitutional privilege against liability when the defamed person is neither a public figure nor a public official. In a 5-4 decision authored by Justice Powell, the court ruled that the actual malice standard doesn't apply to private individuals. Rather, the court permitted the states to determine the appropriate standard of care for publishers that defame private individuals, as long as that standard requires some level of fault. The court's reasoning was twofold. First, the court recognized that the actual malice standard articulated in New York Times was too heavy a burden for private individuals. The court reasoned that private individuals are generally unable to publicly rebut false statements because they lack access to the channels of mass communication. Thus, private parties are more vulnerable to published falsehoods. Second, the court noted that public officials understand and accept the risk of public scrutiny when they take office. The public commonly takes an interest not only in the officials' performance of their duties, but also in the makings of their private life. In contrast, private individuals never signed up for public scrutiny. The court held that private individuals don't have to meet the actual malice standard to recover damages for the publication of injurious falsehoods, even if the defamatory statement relates to a matter of public interest. The court further held that awarding presumptive and punitive damages, as typically applied at common law, required a showing of actual malice. Applying these rules, the court determined that Gertz was neither a public official nor a public figure. As a result, the lower courts had erred in applying the New York Times standard. The court reversed the Seventh Circuit and remanded the case for a new trial. Justice Blackmun wrote a concurring opinion, praising the majority for resolving the uncertainty engendered by the court's previous defamation jurisprudence. Justice Douglas dissented. He suggested that libel laws were already too strict, and he questioned the majority's wisdom in permitting the states to determine their own liability standards. Justice Brennan also dissented, raising the concern that debate can't flourish if states can impose minimal thresholds of fault on publishers for defaming private individuals. Rather, Justice Brennan would have applied the actual malice standard to Gertz as a private individual and upheld the ruling of the lower courts. Finally, Justice White's lengthy dissent admonished the majority for overreaching by invalidating state laws on defamation. White specifically took issue with the constitutional requirement created by the majority, which requires the plaintiff to prove some level of fault on the publisher's part and actual damage to the plaintiff's reputation. He argued that, in so doing, the majority radically transformed the traditional law of libel and intruded on the state's prerogatives. Justice White also criticized the majority for barring recovery of punitive damages without a showing of actual malice. In Gertz, the court created a boundary for the actual malice standard previously announced in New York Times v. Sullivan, refusing to apply it to private individuals. In doing so, the court injected some certainty into the court's defamation jurisprudence.